the U.S. Supreme Court ruled against immigrants with temporary protected status, TPS holders, but that ruling does not affect every TPS holders. In this video, I'll talk about the latest in immigration news. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, please go ahead and like, share, and don't forget to comment below. Let's get right into it. What's really going on? Yesterday, remember, I came here with great news, 4 great news, and then later on in the afternoon of yesterday, something came up, the ruling of the U.S. Supreme Court against TPS holders. Okay, not every TPS holder, only TPS holders with illegal entrance. So basically entry without inspection. So we are going to talk about the ruling and what does it mean for other TPS holders and what can you possibly do, okay? Let's get right into it. What's going on? What's going on is that the case was brought before the U.S. Supreme Court and the decision came yesterday. The issue before the court was they were supposed to decide, right, on whether people who entered the country illegally and were given humanitarian protection were ever admitted into the United States under immigration law. Basically, in simpler, let me put it in simpler words, okay? It simply means that whether a person with a TPS holder status who enter the U.S. illegally can now adjust status in the U.S. Is it possible? Will that TPS status be considered admission? So that was the real question there. Will that TPS or whether the TPS status will be considered admission? And the court decided, no, it's not admission. Admission means that you were inspected at the port of entry or you were paroled at the port of entry. Parole simply means permission to enter. You were given permission to enter at the port of entry. Remember, when somebody gets in the U.S. under U.S. immigration law, the person must either have a visa or parole. So basically that's it. You gotta have a visa, and then when you get at the airport, you get inspected and they admit you in the U.S. That's how it works. For some people without visa, they get parole. Most of the time it happens at the border where the officer will actually ask you why you are coming to the U.S. Some people want to apply for asylum and they get parole, permission to enter so that they can apply for asylum in the U.S. So that's considered inspection and that's considered admission. So without it, later on, whatever status that you are being given will not pretty much replace admission as we know it. So basically that was the problem. The problem was actually solved or not solved for certain, but at least the decision came, and the decision just refer us back to the same law that we already know. Entry without permission is it's pretty much considered inadmissibility, and the person is barred later on from adjusting status. So that's what happened with this individual with a TPS protected status. So basically TPS holders. So what happened again? What happened was they went to the Supreme Court trying to find out whether, because they have now a TPS status, which is a non-immigrant status, and it is considered lawful presence, they wanted to see whether the TPS because it was granted, whether it is considered admission, whether that TPS status can in fact replace admission. But unfortunately, the U.S. Supreme Court has decided, and that's final. So now let's talk about possibility. What can you do? If you're in that category of people without admission, there are two options, okay? The first feasible option will be consular processing. Basically, the person has to get out of the U.S. and try to apply from outside of the U.S. Consular processing. But we know with consular processing, there's no guarantee. There's nothing to tell you that will make you feel better, but it is a process. It can work or cannot work. So that's one way. Another way will be to apply for a waiver. But remember, with this U.S. Supreme Court decision, the waiver becomes even more difficult, because remember, the waiver, from the beginning, the waiver is discretionary, okay? Case by case basis, based on proving extreme hardship, and extreme hardship in the context of immigration, U.S. immigration law, it's defined differently, okay? Whether the person can meet those statutory requirements and prove extreme hardship is a question for the officer now to decide whether you have actually proven extreme hardship. And once the extreme hardship has been proven, again, the officer has to exercise discretionary favor and see whether your argument is more favorable for you to be granted that waiver so that you can adjust status inside of the U.S. Those are two ways, difficult ways, but not impossible ways. So those are the two only ways that we have left. So going back to the subject, basically, what I wanted to say is that sometimes we have good news, sometimes we have bad news. And this is really bad because those people have been here since late 90s. In the late 90s, they got here without, illegally. So basically entry without inspection. And later on, they got a TPS status granted. So they wanted to find out whether that granting of TPS will be considered admission. They went all the way to the Supreme Court just to find out that no, it's not going to be considered admission, and they are barred from adjusting status inside of the US. So pretty much they are left with two solutions: waiver or consular processing. Waiver in this case is really difficult based on I believe they probably applied for waiver before. So basically, based on this decision, waiver is almost like impossible. The other option will be consular processing, a very risky option. So now the question is, are they willing to do it? It's up to them. So for other TPS holders, this does not apply to you if you were admitted in the US, pretty much inspected at the port of entry, or parole in the US at the port of entry. This decision does not affect you in any way. And then once it comes time for you to adjust status, because you have been granted a TPS status, it will not affect you. You will adjust status as you should, unless you have other inadmissibility issues unrelated to this one. So that's it. That's it for today. This is what I wanted to say. I believe that I have explained it the best of my ability. If you do not understand it, you want a consultation, remember that consultation fees apply. Phone number is 202-751-2180. Email on display. And don't forget, consultation fees apply as usual. But if you cannot do this consultation just for this question, remember that I'll be doing live sessions. I will, in fact, be doing live session perhaps the last week of June. For the full week, I'll be doing live sessions so that I can answer as many questions as I possibly can. Okay? So stay tuned. I'll put an advertisement on the community so that you know what the time, what date, so that we can go to those live sessions together and trying to tackle those issues and answer those questions to the best of our ability, of course, within the limits of the law. So that's it for today. Bijoux Ngwanda here, immigration lawyer in the DC metropolitan area. Please share, like, share, and don't forget to comment below. Until next time, bye-bye.